Good day, Crime Talk aficionados. We have a great show for you today. We are coming to you from Karlskrona, Sweden. We are here for the lovely Miss Kristen's family reunion. Never been to Sweden before. It's actually quite nice, just like you'd imagine. It's gorgeous. Anyway, let's get to the show today. It's going to be a quick one, but there was a lot of questions yesterday. About the comments made by Judge Hipler in regards to an appeal. All right, there was a hearing yesterday, and Judge Hipler noted that he was going to lift the gag order, but it doesn't mean that people are going to talk at least until after sentencing. The government said and the police said they weren't going to talk about anything until after the sentencing. The defense made a comment, something to the effect of, well, Judge, you never know how these things can go. Not indicating that there was going to be like some attempt to withdraw a plea or anything along those lines, but I think they were concerned about threats or something to that nature. And the judge also noted that there could potentially be an appeal. Now remember, the plea agreement for Bryan Kohberger was that he pled guilty to all 4 counts of first-degree murder and 1 count of burglary, guaranteeing himself 4 consecutive life sentences without the possibility of parole and a 10-year sentence for the burglary to be served consecutively. Now, the plea agreement specifically said that there will be no appeal. That's very standard, ladies and gentlemen. But the judge said that the United States Supreme Court has stated on an Idaho case that they can, in fact, appeal even if there's an appellate waiver. And I mentioned yesterday, I have seen that before. And sometimes an attorney will say there's no issue to appeal. And the client says, no, I want to appeal. And so the attorney has to fulfill that obligation. So there was a case that went all the way to the United States Supreme Court. It is a case called Garza v. Idaho, and you can find it at 586 U.S. 738. It was a United States Supreme Court case in 2019. And it held that the presumption of prejudice for Sixth Amendment ineffective assistance of counsel, as recognized in Roe v. Flores Ortega, applies even when a defendant has signed an appellate waiver. Specifically, when an attorney fails to file a notice of appeal despite the defendant's express instructions, prejudice is presumed without requiring the defendant to show the merits of the underlying claims, regardless of the appellate waiver. All right? So what does that mean? So even if there's an appellate waiver, it says you can't appeal, you can't ask for a reconsideration, you can't file any post-conviction claims. The attorney can say, I want you to appeal this case anyway. And the United States Supreme Court has said, well, you should probably appeal. And then as soon as it gets up to the appellate level, the government will say, here's a valid appellate waiver, and the case will be dismissed. I have seen that in the 10th Circuit in cases where somebody has pled guilty. There has been an appellate waiver. They appeal because they didn't like something as it relates to the sentencing, but the sentencing was in the discretion of the court, and there was nothing to appeal. And as soon as the appellate waiver was filed, the courts dismissed it. So let's take a quick look at Garza v. Idaho. So Gilberto Garza pled guilty to drug charges in Idaho State Court under a plea agreement that included a waiver of his appellate rights. After sentencing, Garza repeatedly instructed his attorney to file an appeal, believing he could challenge aspects of his sentence. His attorney, however, didn't file the notice of appeal, concluding that the appellate waiver made it futile. Why are we going to do this? That was the whole plea deal. You understood it. You went through it on the record with the court. Anyway, Garza later sought post-conviction relief, saying that his attorney was ineffective, arguing that his attorney provided ineffective assistance to counsel by failing to file the appeal as requested. The Idaho courts completely denied any relief, reasoning that the appellate waiver meant Garza could not show prejudice as he likely had no viable appellate issues. The case ultimately reached the United States Supreme Court to address whether prejudice should be presumed when counsel fails to file an appeal despite a defendant's instructions, even with an appellate waiver. So the ultimate holding in that case was the Supreme Court held that when an attorney fails to file a notice of appeal despite the defendant's express instructions, prejudice is presumed for a Sixth Amendment ineffective assistance to counsel claim, regardless of whether the defendant signed an appeal waiver. Now, this goes back to a case called Roe v. Flores-Ortega, which was also decided in 2000, which established that an attorney's failure to follow a client's directive to appeal constitutes deficient performance, and prejudice is presumed because it deprives the defendant of their appellate proceedings entirely. The court clarified that an appeal waiver does not negate this presumption, as waivers do not always bar all appeals. For example, challenges to the validity of the plea or the sentencing exceeds the statutory maximum. That would be the case in normally a federal case. But no judge is going to impose an illegal sentence, and that could be corrected under Rule 35A. So it really is kind of a moot issue. But it's a procedural thing. They said, well, the attorney says there's nothing to appeal. The client wants to appeal. Attorney has to file the notice of appeal. We'll talk about this in just a second. Anyway, thus, Garza was not required to demonstrate the merits of his potential appeal to establish prejudice, and the court reversed and remanded the case, whereupon they ultimately found that there was an appellate waiver and the attorney was not ineffective. Bottom line, it's not going anywhere. So everyone that was worried, saw a lot of comments yesterday in the comment section that, what does this mean that Bryan Kohberger could appeal? Well, what's there to an appeal? It was a no involuntary waiver of his rights. He admitted that there was a factual basis, i.e. he said he committed the crimes. He was satisfied with his attorneys, was satisfied that they had reviewed all the discovery, and he made a no involuntary plea. The court engaged in that colloquy with Bryan Kohberger, and the court found that he made a no involuntary admission of guilt and that he knowingly waived his rights to proceed to trial. He did that knowingly, voluntarily, wasn't under the influence of drugs or alcohol, and didn't suffer from any mental disease or defect. The court accepted his plea. The sentencing next week, simply perfunctory. People will get up and say their piece if they qualify to make a statement, and he will be sentenced to life without parole. There will be no appeal, ladies and gentlemen, and even if there is an appeal, it will be thrown out because there was an appellate waiver. Unless the judge gives an illegal sentence, which Judge Hipler is not going to do. It's, let's say, for example, on the burglary charge, he wants to give him 20 years when he can only impose 10. That would be an illegal sentence. The judge isn't going to do that. But if he did, then he could appeal that, and that would be the only reason that could possibly take place. So rest assured, Bryan Kohberger is going to prison for the rest of his life, and no need to worry about any appeals. It's done. It's over. It's finished. Nada. He confessed. He pled guilty. He admitted all the elements of the crime. He is going to prison, ladies and gentlemen. So that's all we have for today. I know it was a quick show, but hey, I'm traveling. But we'll see you next week. And remember, the Constitution matters.